Good afternoon, everyone. Mabuhay at magandang hapon sa inyong lahat. Ako po si Alan Arellano, the Executive Director of the Catholic Educational Association of the Philippines. We would like to greet our viewers on behalf of Father Albert Delvo, our President in the leadership of CEAP. Mary Ann, please join me in welcoming our viewers.
Hello, everyone. Good afternoon to all our administrators, faculty, staff, and students of all our CEAP member schools all over the Philippines. I am Mary Ann Cruz, the Deputy Executive Director of CEAP, and Alan and I will be your moderators for this afternoon.
Yes, Mary Ann, this is our second episode of Magtanong kay Atty Binoy, which we launched during the CEAP Day last February 5.
That is true, Alan. February 5, CEAP Day was our first episode. We are very excited for this second episode. But before that, let us begin this episode by praying the 3 o'clock prayer. Let us remember that we are in the holy presence of God, in the name of the Father, and of the Son, and of the Holy Spirit. Amen. You expired, Jesus, but the source of life gushed forth the souls, and the ocean of mercy opened up for the whole world. O fount of life, unfathomable divine mercy, envelop the whole world and empty yourself out upon us. O blood and water, which gushed forth from the heart of Jesus as a fountain of mercy for us, I trust in you. Holy God, Holy Mighty One, Holy Immortal One, have mercy on us and on the whole world. Holy God, Holy Mighty One, Holy Immortal One, have mercy on us and on the whole world. Holy God, Holy Mighty One, Holy Immortal One, have mercy on us and on the whole world. Amen. Jesus, King of mercy, we trust in you. In the name of the Father, and of the Son, and of the Holy Spirit. Amen.
Yan. Thank you, Mary Ann. Now, we will begin episode 2 of Magtanong kay Atty Binoy. But you know, Mary Ann, Atty Binoy cannot join us today. So he sent someone from his law office to be the one to answer our questions on labor issues today.
Oh, yes, we have a guest lawyer for this episode from the Padilla Law Office. Let us all welcome Attorney Marigold Arroyo.
I am very, very privileged to join you today. Attorney Binoy invited me to pinch hit for him. I hope I will do justice as his pinch hitter. And I hope that I'll be able to answer your questions later on when we do the Q&A.
Okay. You can now share your screen, Attorney, so you can start your presentation.
I prepared a very short. Is it already full screen?
Yes.
Yes, we can see
Okay. So this is just to provide us with an idea of the rights and duties of both employers and employees in labor. When we talk about labor, without the labor, no, without the man and the woman who does the labor, there would be no capital. Vis-a-vis, if there is no capital, then there won't be labor. So the two of them is they have a synergistic relationship. Now, in the Philippines, we are one of a kind because during Marcos' time, when he held both presidential, the executive power and the legislative power, he directed the former Blas Oplen, or the former Labor Secretary Blas Oplen, to come up with a compendium of all labor laws so that they'd be able to launch it on May 1, which became the Labor Day. So Presidential Decree number 442 was enacted, especially on May 1, 1974. This was during the martial law. They say that the one who created or authored the labor code was a non-lawyer because Blas Ople was a non-lawyer. However, later on, you'd find out that there's a lawyer actually who claimed to have authored uh, other laws related to labor, like the 13-month pay. But in this particular case, the Presidential Decree number 442, which is a compendium of all labor laws, that this was authored by Blas Ople. Now, what is this all about? You will see that for us lawyers, we needed to study. It's not really a thick book. All the laws relating to labor, from hiring to labor standards, minimum labor standards, until firing or the termination of employment. So from the beginning of the employment to the termination of employment to labor relations, it's all there. So it is a very, very interesting book in such a way that all those who are engaged in labor and employment can find this very, very helpful. So you will also find there, because it's quite traditional, you will have there the agrarian. No, it used to be also with agrarian law. It was about this time where you have the Comprehensive Agrarian Reform Law, the precursor of the Carper Law. So it's the principal source of labor law, but it is not the only source because you have other laws referring to social legislation or benefits. You have the SSS law, you have you can also find your sources of labor contracts as where you will find the terms and conditions of one's employment with a particular institution or with a particular corporation or company. So practices and policies that will also govern the way that the employees will deal with their employers, or how employers will deal with their employees. The number 4 is what you would call the collective bargaining agreement. This comes about when you have a representative. So a group of people, a group of employees banded together, and then they have authorized one group to be their representative, to be the one to push for their rights or the labor standards they would like with their employer. So in short, there are 3 sources of labor law. So that one that is given by the state, so that's the labor code and other statutes, as well as cases, or Supreme Court decisions, or what we call jurisprudence. And then from the parties themselves, you have your contracts, the company policies, the collective bargaining agreements, even quit claims can be sources of your labor agreements. And then, of course, principles of equity. What do you mean by principles of equity? So we refer to what is reasonable. So we refer also to what is born by good faith. Pag sinasabi natin good faith, ikaw ba ay humarap sa isang tao na gusto mong ibigay ang iyong paggawa ng maayos, ng walang alinlangan. Ikaw naman din na nangangailangan ng paggawa ng isang tao yan, hindi ka ba nanggogoyo in layman's terms, no? So, non-diminution of benefits and a just enrichment. Okay? Now, reminder, when you deal with labor or labor engagement, this is the number 1 reminder that we would have to put to heart. Ignorance of the law excuses no one from compliance therewith. In our case, ignorance of labor law is not an excuse. This is where labor issues come about. Kasi sasabihin nila, hindi ko alam eh. Hindi namin alam. When you talk about kasambahay law, which is another labor issue, hindi namin alam na dapat pala yung kasambahay namin ay kasama sa SSS, Pag-ibig at PhilHealth. Hindi namin alam na ang kasambahay pala ay dapat nirerehistro sa barangay, no? Now, why is this very relevant? Because we would have in our schools or in our convents, we would have people who will not be categorized as regular employees, no? They will be under what you would call kasambahay, drivers. So a particular group of people whose employment is as that of a driver, sila ba ay kasambahay, driver, or regular driver sa isang kumpanya, no, or sa isang school institution. Okay? The next reminder would be employment is a form of contract. Kontrata siya. However, because this is protected by the 1987 Constitution, it is impressed with public interest. So hindi siya basta-basta. May public interest na kasama yan. Now, being the owner of the enterprise, whether it is a school or a regular corporation, it makes employment relations lopsided. Ibig sabihin, pabor na kaagad para sa nang-iempleyo. So, kaya naman ang ating mga batas paggawa ay laging pabor sa mga manggagawa. However, this particular, there's a balance to this that we have to achieve. One cannot oppress the other. So it's not always in favor of labor, and neither is it always lopsided in favor of the employers. So reminder number 2. This reminder says that at the end of the day, because employees are at the disadvantage, so we would there are laws that allow that were enacted to allow them to be on equal footing with their employers. That's why we have special laws such as Parental Leave Act. We have laws for solo parents. We have those laws so that even those who have no spouses will be able to take leaves, no, without being penalized or sanctioned by their corporation or by their company or by the schools themselves. So reminder number 2 again, no, additional, it would be about minimum standards and basic requirements. So ano ba ang pinaka-basic na requirements? Siyempre, dapat kung ikaw ay mag-iempleyo, dapat meron kang offer dun sa taong na empleyo mo at ibibigay mo sa kanya ang minimum terms and conditions niya, na ano bang mga kondisyones niya ng pag-empleyo. And then that should be, as a lawyer and as your lawyer, everything should be documented. That is where issues in labor law come in. Why? Because there's no documentation. Hahanapan mo, nasaan ho yung ninyo? Nasaan ho yung kontrata niyo for this? Ay, attorney, wala po eh. Why? Because at the end of the day, please take note of this. Dito kami laging nadadali as lawyers for management or corporations and in schools also. At the end of the day, Article 4 of the Labor Code will tell you that it's always, the interpretation is always in favor of employees. Pag merong doubt, it's always in favor of employees. I'll give you a primary example. RA 7641, have you heard of this? The retirement law for private schools. At one point, I had to handle, when Attorney Sabino Padilla Jr. was still with us, I was privileged enough to handle the retirement cases, no? And we were, because as a lawyer, you are not just litigators, you are also advocates. Pag binasa niyo ho yung RA 7641, sinasabi ho doon, no, na ang babayaran niyo ay a half-month salary for every year of service. Natatandaan niyo po ba yon? Ngayon, pag sinabi nilang half-month of salary for every year of service, meron silang computation kung anong binubuo ng half-month for every year of service. Dito na ho kami nagkatalo ng labor arbiter, ng NLRC, hanggang sa dinala namin yan sa Court of Appeals, hanggang sa dinala namin yan sa Supreme Court. Nanalo kami nung una, tapos later on, binago. Si confessor ho ang naging balakid talaga. Kasi ang interpretation ni confessor ng half-month salary ay buo ho yung service incentive leave na 5 days. So ang computation ho namin na 17.5 na dapat lang ho talaga kasi pag binasa mo, when you go back, no, when you interpret the laws under statutory construction, when you interpret a law, you have to go back to how a law was created. Ano ba ang naging proceedings while the law was being deliberated upon. When that particular law, retirement law providing for retirement benefits for private institutions, for private companies, kasi dati wala, no? And for those who already have it, then exempted na sila. For those who have it, they have to have one. Alam niyo yung ginawa? Imbis na 17.5 ang computation ho natin, half month, ay 22.5 days. Ganun ho kalaki ang diferensya. Siyempre, kailangan nating i-advocate yan. Hindi ho tayo nagsasabi na, dahil ang iba hong interpretation, yan ho ang kagandahan ng pagiging advocate or pagiging abogado. Kasi you get to interpret the law. You get to interpret, you get to advocate for the position of your client, no? 17.5 days. Computin nyo ho yan, ang laki ho yan. So, at the end of the day, because we were creating judicial legislation at the time, what happened was, nung nagpalit ng mga justices, at the end of the day, dumaan ang mga panahon, naging 22.5 days na ang naging computation. At ang naging ko na lang namin dyan ay ang kaso ni Lavandera, no? Lavandera. Yan, tawag namin dyan, Lavandera case. So, ang kwan pa rin natin ay 30 days. 22.5 is what we call the half-month salary. Why? Because in case of doubt, reminder number 2, it's to be interpreted always in favor of employees. If there is any doubt, no? All right. So this particular slide will just, I'm just showing to you in this particular slide the various provisions of the Constitution upon which we anchor all interpretations and all laws relating to labor. Ang ganda-ganda ng sinabi ng saligang batas natin. Tandaan niyo po pag sinabi nating saligang batas, ito yung ating saligan natin. Ito yung pinaninindigan natin. Ito yung sa English, fundamental law of the land. At ang sinabi ho ng Article 2, where you have your fundamental rights, no? Section 18 ang sabi niya sa English, the state affirms labor as a primary social economic force. Ang sabi sabi natin, we will protect the rights of labor and promote their welfare. So, yan ang sinasabi natin dito. Rights of workers and promote their welfare. Napakabigat ho nito. So, when you move further into the Constitution, you will find a particular article of the Constitution, the 1987 Constitution, which specifically provides for provisions on labor. Ano mga pinagsasabi ng saligang batas natin dito? That the state shall afford full protection to labor, mapa-local man lang, no? Domestic, at kahit yung mga lumalabas sa bansa natin. Because by the time this Constitution was enacted or was ratified, no? Marami na tayong mga overseas workers. So this is in recognition that we already have Filipinos working abroad. Yung 1960s na lang natin, di ba? Ang daming pumunta sa Hawaii. Pag pumunta kayo sa Hawaii, ang daming mga Ilocano doon. Bakit? Sila yung mga unang tinatawag nating migration, no, of Filipinos, na sila yung mga nagpipik sa cherries, nagpipik sa orchards, sila yon. So, at yung pangalawang phrase dito, organized and unorganized. Pag sinabi natin organized, ito yung mga unions. Pag sinabi natin hindi organized, ito yung mga walang unions. Pero kahit na wala kang unions, wala kang representation, hindi ka organized, ikaw pa rin ay protektado ng ating saligang batas. Why? Because it is the objective of the state to promote full employment. And take note, it is for the equality of employment opportunities. Dapat merong employment opportunities, lalong-lalo na sa mga gagraduate ng grade 12. Kaya ngayon, nagbabago na naman ang kanilang sa Congress, no? Sa both the lower house and the upper house. They're already thinking, so GMA at the time said, no, let's follow the system outside of our country because we're the only ones left without we're the only ones following the K-10. We actually just have grade 1 up to 10. Yung iba nga, optional pa lang yung kinder. No, let's follow our Western countries and even the Asian countries who followed K plus 12 para naman maging makasabay tayo. And then later on, they're saying, oh, teka muna, may pa na ba? Meron na bang study to say that this K plus 12 is not working? Sabi na naman nila, itong si Congressman Romulo, ay through GMA again, they're pushing now for a bill that allows a student to graduate and immediately work. Kung ayaw mo na mag-11 and 12, magpunta ka na daw sa TESDA at magtrabaho ka na. No? So now, ang tanong dyan, may child labor ba? Kasi by the time na mag-graduate ang isang grade 10, anong taon siya? 16 years old, 17 years old. Swerte na lang kung yan ay 18 years old. So is that child labor? Well, you can ask me that question later. Now, the second paragraph of Article 13, Section 3 is very, very interesting. Why? Because the Constitution itself said that it shall guarantee the rights of all workers to self-organization, collective bargaining and negotiations, and peaceful concerted activities, including the right to strike. Pero this is in accordance with law. In the 1970s, during martial law, naglabas na ng presidential decree noon si dating Presidente Marcos, recognizing. Dati tinanggal nila yung right to strike. Bakit? I don't know if you've heard of the La Tondena case, kung saan maraming nasawi, maraming nasaktan. So nagkaroon ng strike. Yan. So noong 1970s, punong-puno ng kaguluhan hanggang sa 1980s. Kung kaya naman nagkaroon tayo ng people power, which we're going to celebrate, by the way. When? Oh, this coming Sunday, no? February 25. I hope we will always remember why we have to reminisce, why we have to remember why there is a February 25. Okay. But it is only us, us who lived through that time, who were born and who lived through the 1980s, 1990s, who understand where this particular provision of the 1987 Constitution comes from. So the third paragraph of Section 3 will talk about the shared responsibility between workers and employers. Ito na yung binanggit ko kanina na synergistic relationship between workers and employers. Hindi ibig sabihin na hihilahin mo pababa yung nagbigay ng kapital, di ba? Or ikaw naman na nagbigay ng kapital, ikaw naman, you will oppress yung iyong manggagawa. No, it's a shared responsibility so that you will have a thriving institution or a thriving corporation where you will have a return on your investment. That is why it was enshrined in the Constitution the alternative or voluntary modes of settling disputes, which includes conciliation, mediation. Why? This is to foster industrial peace. Again, this is a reaction to what happened in the 1970s na kadami-daming pangyayari. Ang napaka-popular noon ay ang tinatawag natin Kilusang Mayong Uno. Kilusang Mayong Uno, KMU. Mayo Uno, because it is Labor Day. No? Kaya sila very popular. Why? Because there was really a feeling that the workers were oppressed. And it's only those who were rich who became richer. All right. And the last paragraph of which is that the state has the right to regulate the relations between workers and employers. On Monday, just for your information, the Magna Carta for seafarers will be signed into law by President Marcos. So the Magna Carta of Seafarers Act, Tatak Pinoy Act, and the Centenarians Act will all be signed into law. They all relate to protection of the welfare of the people. So, any piece of legislation relating to workers, we call that social legislation. This is to promote public welfare. So, any law that provide protection or benefit to society or any segment thereof, we call that a form of social legislation. Kasama na dito ang SSS law, ang revamped PhilHealth law. Yan. Kasama na yan dyan. Naalala nyo nitong recently, napaka-popular yung isang very popular coffee shop, no? Pinagalitan siya because this particular coffee shop was not computing the 20% off ng mga senior citizens. So the Senior Citizens Act is also a form of social legislation. Isa pa, do you remember? It's the Disability Act, no? So these are forms of social legislation, even though there is no employer-employee relationship that you can gather from those laws. Wow. So rights of employees or the workers, in short, it's freedom from slavery. So I'm not sure if you've lived long enough, but history will tell us about the slavery, the form of slavery that happened doon sa mga workers na nagtatrabaho sa sugar centrals, no? So now we have a very advanced form of provision of the law on security of tenure. This is where your provision of the law on probationary employment comes in. So 6 months. Why is it different from the probationary employment of 3 years? So you can ask me that, and then I can explain it later, no? And then, of course, the enhanced due process law. And then another right of the employee or slash workers would be the right to self-organization and labor standards, so non-discrimination and equal opportunity and terms and conditions of employment, which should all be provided or enshrined or written down in your in your contract or in your collective bargaining agreement. Now, I specifically did not do away with discussing briefly the concept of due process because this is at the heart of any labor law issue. What is due process? It is the act of providing both parties to a controversy the right to present their side. Karapatan nila na makapagbigay, na magkakaroon ng pagkakataon na maibigay nila ang kanilang side, no? Ang kanilang gustong sabihin. Kapag meron kang charges, kailangan sila rin ay maaaring makapag-ventilate ng kanilang position on the matter. So, that's due process. So, a party accused of wrongdoing, ito ang pinaka number 1 requirement ng due process. Notice in writing kung ano ang kanyang infraction, ano ba ang kanyang pagkakamali. At yung pagkakamali niyang yun, saan yan, bakit siya nagkamali? Nakalagay ba yan sa Employees Code of Discipline? Nakalagay ba yan sa inyong kontrata? Nakalagay ba yan sa Labor Code? Kung hindi man nakalagay sa Employees Code of Discipline, hindi man nakalagay sa inyong kontrata, nakalagay ba yan sa inyong Employees Code of Discipline o kaya sa MORFED o kaya sa Manual of Regulations for Private Schools, di ba? Ngayon, nilagay ko na lang din dito para lang madagdagan ang ating kaalaman, no? Kung hindi pa natin natatandaan ito, if the party involved is a student, the parent must also be notified in writing. It's not the student who will be answering. It's the parent considering they are young. They are innocent individuals. So in case a person is accused of an offense and this person, the employee, denies the charge, sabi niya, hindi ko ginawa yan. Kasi ganito, ganyan. Well, in this case, the school or the corporation, you must convene a fact-finding committee. You are duty-bound to convene a fact-finding committee and allow the parties to present their evidence. Ngayon, specifically in our context, no, in the CEAP, we have teachers. They have the right to be respected by the community, to be formally informed of the terms and conditions of employment. So this is usually where labor issues come from. So now the duty of the school is to craft and furnish the teacher with a contract containing such terms. And of course, you have to be paid your salary as it falls due. Okay? Depende yan sa usapan nyo kung anong usapan nyo. Usually 15 to 30 or once a month. And of course, security of tenure. This is for permanent staff. So meron tayong dalawang klase, those who are covered under the probationary employment of 6 months and those under covered by the 3-year rule. So to gauge the school on questions regarding employment, hindi maaaring sabihin ng school, no, yan na yung ating usapan. Hindi ka pwede magtanong na beyond that. No. They have the right to engage the school in questions regarding employment because it is not a dictatorship. Remember, it is a synergistic relationship between employers and employees or the school and their employees or teachers. Okay? So we've already mentioned due process. So now, these are the other rights of teachers. Okay? Kailangan meron silang performance evaluation. Kailangan bigyan nyo sila ng suggestions kung paano sila makapagpabuti ng kanilang pagtuturo. And they should have also the right to recommend any change in school policies and to be able to pursue higher education. So these are the other rights of teachers. Okay? These are the other rights of teachers. So essentially, I just enumerated here the rights of teachers as I saw in my practice. No? And of course, we have what we call the administrative process for teachers who allegedly committed infractions and who should be penalized or sanctioned. So kailangan meron din tayong grievance mechanism for settlement of any issue regarding employment relations. And it should be referred to this grievance machinery. Bago pa yan makarating sa SENA, sa single entry ng NLRC, dapat meron tayong grievance machinery. So, again, uulitin ko, disputes and offenses should be made of record. So, document. All right, notify them, no? Now, so of course, at the end of the day, they should be able to come up with a resolution. The fact-finding committee should be able to come up with a resolution, either absolving the erring faculty or the erring employee, or making this employee liable and provide the sanctions. Now, can the school or can a corporation issue preventive suspension? The answer is yes. Start with 30 days, but it cannot last more than 60 days. Now, these are the grounds for dismissal of teachers. You should find them in your employees' code of discipline, in your contract, as well as in the labor code. Neglect of duty kadalasan ito. Ito, meron tayong immoral conduct yan. Especially, this is very, very important, no, with our situation, being a member of a group of Catholic schools. So probationary contracts, it's 3 years for teachers, 6 months for non-teaching staff. Kailangan may kopya sila ng kontrata nila, pati ng faculty manual. Ang ginagawa ng iba, sa library ho, yung inyong kopya ng faculty manual. Pwede na ba yun? Now, what are the rights of employers? Of course, if the employees have rights, if the teachers have rights, if the non-teaching staff have rights, the employers also have rights. The rights to ownership, the return of their investment, expansion and growth, the use of their ownership, and to sell and dispose of their property. So, contracts, and when they enter in a contract, they have the right to select kung sinong gusto nilang i-hire and to terminate. And of course, we have what we call management control and prerogative. So ano bang sinabi ng Supreme Court? Supreme Court in the case of BPI Employees Union versus BPI in 2013 said the BPI's policy of contracting out cashiering and bookkeeping services, it was considered as a valid exercise of management prerogative, which is further authorized by the central bank. All right. What about this case of Zuelig Pharma? Also in 2013, the collective bargaining agreement, whether in the pharmaceutical corporation or in the setup of a school institution, it is the law between the parties. Now, in this case, the complaining employees were not entitled to the monetary equivalent of their unused sick leave credits because the collective bargaining agreement, the existing company policies, and the quit claims do not cover them. So interesting, right? It was not just the collective bargaining agreement. The Supreme Court said that it also included they also included the existing company policies and the quit claims. And in the last case of Abbott Laboratories, also in 2013, Abbott Laboratories was held liable for 30,000 for as indemnity because it did not follow the procedural process in terminating their probationary employee. So, attorney, probationary employee lang naman siya. So, bakit kailangan pa mag-follow? Kailangan pa rin. Kailangan pa rin yun yung bigyan siya ng pagkakataon. Kung bakit siya ninyo hindi gagawing regular. Interesting, no? So, but the company employers here were not held liable personally because there was no proof that they acted in bad faith or they were motivated with ill will. Meaning, the employees concerned wanted the officers to be jointly and severally liable. Ibig sabihin, personally liable sila with the corporation. Okay, I will leave you with these thoughts. The balancing of rights. So there's the recognition of management rights. Kanina kasi nagsimula tayo parang no, it's all about the rights of the employees. But I kept repeating it's a synergistic relationship between employers and employees. So it's a balancing of rights, and that's what when ang inyong particular na usapin ay makarating man sa labor arbiters, NLRC, sa Court of Appeals hanggang sa Supreme Court, they will always balance your rights. It's a recognition of management rights because they're entitled to respect and enforcement in the interest of fair play and the principle of non-oppression. Okay, so neither capital nor labor shall act oppressively against other or impair the interest or convenience of the public. Na? Okay ba? So it's not all about the employees and neither is it all about the employers. So these are just sample cases, but they're just going to elucidate the concept of recognition of management rights and the principle of non-oppression. So I hope by this time you have already, I have already titillated your imagination as well as your quest for knowledge. No, I am free to answer your questions in the time that we have left. Okay, but before that, let me recap on this management rights, right to return on investment, prescribe rules, select employees, transfer, even discharge employees. Yan. Okay? So, we are also bound by international laws. So that is why we now have in Congress insurance law, employment insurance law. It's a bill that when you have no work, the employment insurance will kick in, and the government now, or this insurance law will kick in and will provide you with cash while you are still looking for work. Sa states, ganyan eh. Kwan tayo, signatory tayo sa International Labor Organization, sa mga treaties referring to insurance, employment insurance. So gusto na natin ipasayan dito sa Pilipinas. To no avail. Wala pa rin. Tingnan natin kasi masyado nang magastos eh. Now, final words. In the engagement of labor and capital, I hope you're familiar with the great Abraham Lincoln. He said, labor is prior to and independent of capital. Capital is only the fruit of labor and could not have existed if labor had not first existed. Labor is superior of capital and deserves much the higher consideration. With that, I leave you and I'll be ready to answer your questions after our break. Ma'am Mean?
And we're back. Handa na ba tayong magtanong kay Atty Binoy?
Yes, we are, Mary Ann. And pero kay Attorney Marie muna tayo magtatanong, ha? Baka makalimutan natin.
Oo nga pala. Are you ready, Atty Mary? We have some questions from your viewers, and some of them were sent ahead of time to us. Ready na ba ikaw, Attorney?
Hala. I will try my best.
Sige, ako na una magbabato ng tanong. Oo.
Okay.
Oo. Attorney, hindi ko alam kung seryoso ang tanong na to. Ano po ba ang pwedeng ikaso sa boss na laging galit, nagmumura, at namamahiya ng mga empleyado to the extent na nagiging stressor na siya at nagkaka-mental health issues na yung mga tao niya?
Mental health pala ito, Attorney. Ano masasabi?
Unfortunately po, wala pa tayong mental health law, ano? So, pero kinakasa na rin yan sa ating mababang kapulungan. However, pero, no, yung mga ganyang problema, pwede yung pumasok sa tinatawag nating serious misconduct under the labor code. Okay? Ano ba tinatawag nating serious misconduct? Talagang kailangan seryoso to na maling pag-aasal. Ang serious misconduct, hindi lamang to para sa mga, kumbaga, tawagin nating ordinaryong empleyado as opposed to management, di ba? O hindi boss, di ba? Pati ang mga boss, pwede rin nating filean ng serious misconduct. Okay? What is the definition of serious misconduct? Well, according to the labor code, it is any action or inaction, kahit yung hindi paggawa, any action or inaction, baka ito yung mga tinatawag nating passive-aggressive, di ba? Bringing the effect of destroying or undermining the relationship of trust and confidence between and among employees. Yan, serious misconduct yan. Yan tinatawag nating mali, no? Transgression of some established and definite rule of action, a forbidden act, a dereliction of duty. Kailangan willful in character, tsaka merong wrongful intent at hindi lang maling pag-iisip or maling tinatawag namin na error in judgment, no? Hindi. Kailangan deliberate. So, ang pag tinanggalan ka na ng dignity mo bilang tao, yan, serious misconduct yan. Diba? Kailangan may respeto ka pa rin sa empleyado mo. Kahit na ikaw ang boss. Tama po ba, ma'am?
Tama. O, next question, attorney. Kanina sinabi mo na to, no? Sige, itanong niyo sa akin mamaya. When do you consider child labor? Kailan natin masasabi ay ito ay child labor, hindi requirements sa school or ano ba?
Meron talagang law na nagbabawal ng child labor. Ito yung Republic Act number 9231. It is the special protection of children against child abuse, exploitation, and discrimination. So, ang bata na nagtatrabaho below 15, no? Below 15, yan ay tawag natin child labor. Except, ayan, merong mga exceptions. Paano yung mga artista, attorney? Di ba may mga batang artista? Hindi ba yan child labor? Exception yun. Pwede siya pumasok sa exception. Pumayag ang parents, pumayag ang nanay, may kontrata sila, at ang bata ay hindi nagtatrabaho more than 20 hours a week, at 4 na oras lang sa isang araw, at hindi nagtatrabaho beyond 8 o'clock in the evening. Yan. Paglagpas naman ng 15 na edad, pwede magtrabaho hanggang 40 years old. Bago mag-18 pwede magtrabaho hanggang 40 hours. Pero, hindi naman sumusobra sa 4 na oras sa isang araw. Yan. Yan ang mga requisitos or mga requirements ng batas na para protektahan ang mga kabataan sa child labor. Yan. Yan ang ibig sabihin ng kwan. Napakaganda, di ba, no? Kasi kwan tayo signatory tayo sa International Law for Protection of Children. It's a human right. It's a child's right to be able to
enjoy
their childhood, na makapaglaro sila. Hindi yung nagtitinda sila ng sampagita. Ma'am, nakakita pa ba kayo ng nagtitinda ng sampagita sa may GMA7? That's a form of child labor.
Sa simbahan, laging meron nagbebenta ng
So it's exempted ba sila porque nandun yung parent? Well, you can argue. You can argue that way.
Yata nagpapabenta sa kanila, di ba?
You can argue it that way na pwede. Kasi kapag may allowed ng parent, allowed ng bata, may consent, pwede.
Next
Okay.
question.
Thank you, attorney. Yung second, yung next question natin, siguro ito meron pang hangover ng Pasko, no? How do you compute tenuity and 13th month pay? Napaka-basic, no?
Oo. Yung 13-month pay na lang.
Sige po.
Yung 13-month pay, medyo mahaba-haba yung tenure, di ba? Yung 13-month pay, napakaganda ng history nito si Attorney Zoilo de la Cruz at also dating Congressman de la Cruz na taga Visayas. Siyang nag-conceptualize ng 13-month pay that at the end of the 12-year in a 12-month period, di ba? Dapat equivalent 1 month salary. Paano kapag may absences, di ba? Di syempre kung ano lang yung kanyang kinita, basic salary niya sa isang buwan. So lahat ng kinita niya sa isang buwan. So kung ang basic salary niya ay 12,500, walang absences, i-times 12 mo siya, di ba? Times 12 divided by 12, yan ang kuwan mo. Yan ang you calculate the employee's total basic salary earned during the calendar year. Isama mo yung mga allowances.
Okay.
Kung kasama sila sa basic salary. So,
Mhm.
i-adjust mo yung absences, di ba? Pag part-time ba, merong 13-month pay? Yes. You calculate the 13-month pay, you add all the basic monthly salaries and during the calendar year, and you divide it by 12.
So,
Oh, that's
Sarap,
why
no?
pala when I was a teacher years back and I had a leave, no, because I had a surgery. Yung 13th month pay ko got affected because of the
correct.
month leave that I took.
No
Ganun.
work, no pay.
Oo. After the sick leave is used up, no? Parang,
Oo.
Yes, yes.
oh,
Tama. Tama.
next question. Ito po. If an employee resigns after 20 years of service, what is the financial responsibility of the school?
Nako po.
Ano to?
Wala.
Kapag resignation, wala?
Wala. That's the first rule. Kasi ang resignation is a voluntary act of the employee to terminate his or her employment. Okay? That's a voluntary act. However, eto na, kung ang kanilang employees manual, merong provision doon na kahit na mag-resign ka, ay kung ikaw ay nakaabot na ng 20 years, as in this case, no? Yung question natin dito, may makukuha ka, di ba? Naalala ko nung sa meron tayong CEAP, may mga
Retirement.
schools na merong CEAP, parang after 10 years, meron silang
Oh,
makukuha.
retirement.
After
So retirement,
15 years.
yes.
Not even retirement, sir, eh. Ang alam ko meron silang ganun.
Oh, it's a CAP,
Yeah.
it's part of the CAP retirement plan.
Meron sila.
Yes.
So,
Kasi kami ni Mr. Arellano, nag-resign kami as
Nakakuha kami.
we got.
oo,
Kasi
diba?
kasama sa manual. Nakalagay
Kung
sa...
kasama yan sa manual. Pero ang unang rule, resignation, kahit matagal ka pa dyan, wala kang makukuha. Kasi, umalis ka eh. Dahil maraming, dyan ang labor issue, ang tagal-tagal ko na. Diba? Lagi nila sinasabi yan.
Kaya pala, yung isang friend ko nag-resign siya, parang 10 years or 20 years siya sa school din. Wala siyang nakuha. Because pag resignation, wala. Okay, next question.
Eto, hangover din to ng araw ng mga puso siguro last week, no? Bawal po bang magkaroon ng kasintahan sa isang opisina, sa isang paaralan, at may batas ba sa DOLE na nailathala na tungkol dito?
Bawal ba magka-boyfriend?
Wala po.
Ang asawa?
Wala.
So walang ganon.
Wala. Pero, ayan, kapag ito nakalagay sa inyong employees manual at ikaw ay pumayag dahil pumirma ka ng kontrata na pumapayag ka sa regulasyon na ito, you are covered.
Okay.
You are covered.
So pag nasusulat, pag nasusulat.
So
Okay,
kung may
next.
nakikita kayong na pwede kayong magkaroon ng love life sa opisina, huwag kayong pipirma. Ganun po ba 'yon?
Pagbawal,
Pag may nakita.
Pag nakita nyo pa lang first day nyo, huwag muna kayong
May
pumirma sa
gwapo, ganon.
manual.
May gwapo. Teka, hindi ako pipirma dito.
Tama.
Ito,
Oo.
ito yata, lagi yata itong nalilate. What is the remedy if the employee is always late in coming to work? Meron to mga nalilate na employees from Joy Biasong of Voctech Academy.
Naku naman, ma'am. Ma'am Joy, syempre po, bawasan nyo sa sweldo. Syempre, di ba? Ang kuha natin ang principle of no work, no pay.
Okay.
Eh di syempre, yung meron na siyang hindi pinasok, di ba, na ilang minuto. Syempre, nakalagay yan lahat sa inyong Employees Code of Discipline. Halimbawa, ikaw ay na-late ng 15 minutes. First time mo, bawas na kagad. Pag second time, tapos ma-minus yun na yan. Nakalagay ho yan dapat lahat sa inyong Employees Code of Discipline. Kasi pag nakapangatlo ka na, may sanction ka na. Dapat suspension ka ng 1 day. May mga ganyan. Depende na yan sa inyo. Depende sa school. Depende yan sa korporasyon kung paano gagawin. Kung paano nyo isa-sanction yan. Deterrent talaga kapag may bawas sa sweldo.
Correct.
Ito, attorney, galing ito sa isang madre pero hindi ko napapangalanan kasi baka ma-identify yung tao, no?
Okay.
How long is the indefinite leave of an employee? We have an employee who got sick since September last year. She's scheduled for an operation on April 2024. I don't know what's next after her operation. At the moment, she's not in good shape. She has been in school as office staff for more than 15 years. Thank you and God bless. Madre talaga nung ipa-God bless.
Thank you, sister. Okay, so unfortunately, pag minsan meron tayong mga empleyado na matagal na sa atin pero biglang nagkakasakit, ano? So anong gagawin natin dyan? So syempre naman, hindi naman niya ginusto yon. Pero paano yan? Masisira naman yung operations natin, di ba? Anong gagawin natin? Magpapasubstitute ba tayo or hindi? Fortunately, meron tayo sa batas. Mismo sa Labor Code, Article 284. Ang sinasabi doon, ang pagkakaroon ng sakit, no, ay isang kadahilanan para ma-terminate yung inyong employer-employee relationship. Okay? Pwede siya. Ngayon, sa civil service rules, although hindi tayo gobyerno, ang kanila ay 1 year. Okay? 1 year na sick leave allowed sa kanila.
No?
So, particularly dito sa Article 284 ng Labor Code, na kapag may sakit ka, o kaya yung patuloy mo na pagtatrabaho, magkakasakit naman yung iba, pwede na ma-terminate yung relationship. Provided you are paid separation pay. Ayan.
Okay.
May separation pay siya.
Oh.
For every year of service, whichever is greater. A fraction of at least 6 months being considered as 1 whole year. Yun. So, depende
Mas
sa
always in
situation.
favor of the employee kasi, no? So, whichever
yeah.
is greater.
Yes.
Okay. Sige, next question. Pero bago yan, magpapasalamat tayo kay Dr. Teresita Surot for sending us stars. Hello, Tessa.
Thank you,
for
Dr. Tess.
stars. Ito po. How many months ang usual bago required na ma-full-time ang isang employee? So, how many months of ano ba to? Probationary.
Yun ang tanong dyan eh. Kung probationary employment, pag rank and file, non-teaching staff, 6 months. Okay? So, meron kasi tayong iba't ibang klaseng employment. We have regular, we have casual, yan. Yan yung mga different types of employment natin.
Dito ng seasonal, meron bang
Oo,
ganun?
may seasonal,
Yeah.
tapos meron tayong fixed term, yan. So, iba-ibang klase. So, magkaiba ang regular ha sa casual. So, ang casual employment kasi yung parang you were just plugged in. Saglit ka lang. Yan, ganyan. Kaya siya casual. As opposed to seasonal, kaya siya seasonal because it follows the season. Kaya siya seasonal employee. Okay?
Okay.
Fixed term employment, as in the case nung sa Brent, nalala nyo, o kaya, yung may mga cases, di ba, na ang siya, non-teaching staff, pero 1 year lang yung kanyang period of employment. Yan.
Okay.
So,
Fixed
pero ang
talaga.
mga teachers talaga natin, 3 years. Yan ay exception siya. Exception siya sa 6 months probationary employment.
Okay. Eto siguro, siguro, kasi medyo 2 minutes na lang tayo bago mag-alas 4. Isa siguro to sa mga huling tanong, ano?
Maybe it's the last na.
I am a teacher in a private Catholic school. My administrator hired a public school teacher and she offers service during office hour. So, full-time siyang public school teacher tapos nagtuturo siya dun sa school. Is there any violation on labor law, attorney?
Full-time siya sa public school. Actually, nagva-violate siya ng civil service rule sa government.
Sa government.
Oo, kasi government employee siya. Pero, so, ang pagreklamo niya ay doon sa una muna, magreklamo siya sa DepEd, tapos magreklamo siya sa civil service. Yan.
Okay.
Okay.
Pero allowed ba siya? Why not? Kung wala magrereklamo.
Concerned citizen lang siya, attorney.
Oo.
Wala siyang, pwede rin,
Kasi napagod masyado.
Oo.
Kung baka nawalan siya ng
Kasi-
load or something. Pwede po ba
Or
yun?
ginagawa niya yung pagtuturo niya outside their hours. Kasi
Okay.
allowed, pwede naman.
Wow. So that was an interesting discussion, labor issues, attorney, no?
Bitin.
Medyo bibitin kami ni Me.
Such an eye-opening session this has been. I'm looking forward to the next episode. Kailan ba next episode, Mr. Arellano?
Parang iniisip natin March 22, 2024, 3 p.m. At ano kaya ang susunod nating topic sa episode na yon?
Parang dapat mag-part 2 tayo.
Pwedeng labor issues part 2 kasi ang dami pang tanong na gustong ipasagot sa atin, ano? Wala lang tayong oras.
Correct.
So abangan natin 'yan.
Siguro at this point we can ask Attorney Mary for your closing message.
I will go back to my first statement that that the relationship of the employer and the employee is a synergistic one, that one cannot exist without the other. And so each should be able to recognize that they have a shared responsibility in making the enterprise or their institution in this case a growing one, a thriving institution. That's their duty and their responsibility. Don't worry, the law will take care of your rights and obligations. So thank you very much for inviting me, and I hope you were kahit paano naalala ninyo no yung inyong mga rights and duties as both an employer and an employee. Thank you, ma'am, for inviting me.
Thank you, Attorney, for
Thank you.
that very inspiring closing message. The law will take care of our rights. No, thank you for pitching in for Attorney Binoy today.
Yes, and thank you, attorney. And may I take this opportunity to remind everyone that all episodes of Magtanong kay Attorney Binoy will be saved in the video section of our official Facebook page and in CAP channel on YouTube. If you miss out a session, you can go to these sites to view them again.
In the meantime, please send us your evaluation of today's episode by scanning the QR code on screen. Ayan po. We will pause a bit so that you can scan the QR code on screen. Make sure you type out your email address properly so that you will receive your certificate of participation as soon as you submit the evaluation form. Meron po kasing nagtatanong minsan na bakit hindi nila natatanggap ang kanilang certificate kasi po automatic yon na binibigyan kayo ng evaluation, ng certificate after you evaluate. But you have to make sure that your email address is typed in correctly. So we thank our partner, Raxo City, for that and for helping us broadcast this forum today.
Thank you, Raxo City, our ever-reliable partner. And so, on behalf of our President, Father Albert N. Delvo, the entire CEAP National Board of Trustees, our team from the National Office, I'm Alan Arellano.
And I am Marianne Cruz saying...
Thank you and good afternoon.
Good afternoon, everyone.
Sa ikaw at ako, natuto sa prinsipyong punyo at serbisyong totoo. Kahaling tulad ni Kristo, sa puwarang Katoliko. Pagkakaisa sa tulong at gawa, masasalamat sa biyaya ni Kristo.
Ang kabataan
May hamon at alay,
sa ating bayan,
maging lingkod at
ng
yan.
pagbabago.
Sa misyon sa mundo, Birhen Maria ang gabay at ang modelo. Sa mundong may bagong anyo, isang bansang may bagong sigla. Dahil sa ikaw at ako, natuto sa prinsipyong mundo at serbisyo.